even in my son's case, I have people who are not feeding a child.
Right. There's more visible cues and things like that. I 100% agree with the court.
Okay.
Yeah. I'm not, you know me, Judge. I don't try and oversell things.
No, it does call the case of the People's State of Michigan versus LaPortia Murray.
Interfield is occurring on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein on behalf of Ms. Murray. Your Honor, I apologize for my lateness. Should have scheduled some things a little bit better. And
well, no, I understand that you were down in Judge Slade's court, so we were willing to wait and make sure you got that taken care of in that year. So we're good. All right, very good. The court has received both the people's brief as well as the brief from the defendant, and has reviewed both of those. Was there any additional argument from either side?
I guess the one thing I would like to just make a brief argument.
Yes, that's
My
fine.
colleague, Mr. Evans, did most of the argument on Tuesday, all of it, rather. I will preface this with, I apologize for bringing something up that I think we thought we had put to bed on Tuesday, which is this whole notion of, as in my pleadings regarding the first degree child abuse with the felony murder.
Okay.
Which, as I went down the road of legal research, I, in speaking about candidly with some individuals from PAC's panel regarding their child abuse cases, I discussed the matter, and they pointed me in the direction of this Maison case, which I cited in my pleadings. And I'm not trying to, I know judges don't like it when you keep arguing a point, even though we're lawyers, right? We can't help ourselves sometimes. And so I felt that, based on that law, I had to make that argument. That's included in the brief. And I think,
well, let me ask you about that.
Yeah.
What particular point are you trying to make with the Maison case?
so the important, and stop me if I'm incorrect, but my recollection of Tuesday was the court's concern over child abuse first degree, and then kind of by that, which leads to the felony murder. The court's concern over child abuse first degree was a discussion of what arguments do the people have to show that the defendant in this case did the harm, right? And that was a very, very pointed question by Your Honor to Mr. Evans about that. In reading the Maison case, what the Court of Appeals says is that it's an interpreting child abuse first degree versus second degree. Second degree specifies you can either do it by an act or do it by omission. And child abuse first degree does not discuss the idea of an act versus an omission. And the Court of Appeals concluded that their interpretation of the child abuse first degree does not require an act, and it can be done through an omission if that omission is knowing and willful. And thus causes the harm, a serious physical harm, which I think without question we have a serious injury to Lariah Henning. That's of all the things we can argue, that's not worth arguing. So my argument is that through my reading of the Maison case in analyzing it within the context of the facts before the court, I want to make the argument that through the defendant's conscious decisions to not get Lariah care, and this is in the pleadings, and I think these decisions by the defendant were based on her own statements, fully aware of that Lariah had something going on, right? She made the statements, she thought she would maybe fall, and this, that, and the other. Obviously, it's the people's intention. This hasn't been necessarily borne out by facts that I think the defendant had something to do with that, but that's not important. What's important is that the defendant, by her own admissions, acknowledged that Lariah had suffered harm and that she knew she should take her to the doctor, and that she didn't want to take her to the doctor because she didn't want the doctor to see the physical abuse that she did to Lariah, not necessarily the head trauma, but these other markings that even Dr. Toshkin testified to that were on the body, on the back and things of that nature. And so through the defendant's knowing full well that she needs to take her daughter to the doctor, but she doesn't want to get in trouble, that is a very conscious and intentional decision by the defendant to not take the child for medical care which ultimately likely would have saved her life, but wasn't done. And this was not over the matter of hours or minutes, but this is days that this went on. And
But can I just ask, because as I read the cases where they haven't taken for medical care, that medical care is specifically directed to the injuries that cause the harm. Right? And I guess the court is having a difficult time in this case because had she known, for example, irrespective of the other injuries, of trauma to her head and had failed to do it, I see the argument. Here, I don't have anything that says that.
Well, and I understand that point, and my argument would be that there are facts before the court that would suggest that she knew that this injury was a significant injury, because when pressed by Detective Sinks in her statement to Detective Sinks, she acknowledged that she may have fallen down the stairs in this townhouse in the apartment that they lived in, and that after the fact she was not eating and drinking and had trouble with mobility. Now I'm not saying that the defendant's a doctor or I'm inferring that sort of expertise, but I think as a parent with a 2-year-old that falls down the stairs and then is having all these issues, it's a reasonable to assume that there is some sort of head injury, because what we don't have is any evidence of cuts, bruises, scrapes, vomiting blood, things like that would suggest some other type of injury. But we have someone who's acknowledged that their kid fell, right? Had call it an accident, call it whatever. But we don't have, if it was a situation where Lariah cut her leg, right? And turns out she had also hit her head, but there's not a, the Maison case deals with, starvation, which led to pneumonia, and then the kid ultimately succumbs to the infection. So it's I think the ME testified that in that case that the malnutrition would contribute to the infection because the body's unable to fight off. I don't think that's terribly different than what we have here. We have knowledge by the defendant that her daughter suffered a fall, and that the subsequent effects of that were changes in her motor skills, in her appetite, and her.
But do we really know that? I mean, was that really the testimony? Because in one instance, there's a 4-day period, and then there's like a week period in terms of exhibiting certain symptoms. But I don't know that it was pointed out that that's after the fall.
My recollection of, and again, this is probably part of the issue when we bifurcate an exam like this, which stinks. And so I'm relying on my memory, and my recollection from Detective Sinks' testimony when I asked him the questions about the statement made by the defendant was that the defendant admitted to Detective Sinks that Lariah had fallen down the stairs or had some sort of accident, and that after that occurred, exhibited a loss of appetite and wasn't drinking, as well as issues with mobility. I forget the exact phrasing, and not only that, she admitted to Detective Sinks that based on what happened, she knew she should take Lariah to the doctor, but she didn't want to get herself in trouble because of the injuries and potentially getting CPS involved.
But that was because of but that wasn't because of the fall.
It was because of the fall.
That she wouldn't take her to the hospital?
Yes.
I don't recall that. And maybe you're right in terms of this. You need to go back and look at the record. My recollection of why she didn't take her to the doctor was because of either spankings or parental disciplines or the plastic belt.
No, she didn't want to take her to the doctor to expose those injuries to the doctor, but she, in her statement to Detective Sinks, admitted that she knew she should take her daughter to the doctor because of the fall, because of the effects that Lariah was suffering after the fall.
Okay, and there may be the distinction. It wasn't because of the fall itself, but what is now claimed to be what was being exhibited by the child after the.
Right.
Okay.
Yeah, there was no statement by the defendant that as soon as the fall happened, she realized she should take her. And I don't think there's any, even from a physiological standpoint from Dr. Tashin's testimony, that there necessarily would have been an immediate reaction by Lariah to this traumatic brain injury. I mean, she may have been momentarily incapacitated, who knows, right? The testimony by Dr. Tashin was that the traumatic brain injury caused a swelling of the brain that over this 3 to 5 days increased, and ultimately caused her to die. And that he testified, you would expect symptoms to manifest over that time period, consistent with, frankly, with the observations that the defendant made about her own daughter. These things like loss of appetite, trouble with mobility, whether or not she's speaking, and things of that nature. And so, yeah, there was not a statement that immediately after the fall, I knew I should take her, but there was a statement to Detective Sinks as the defendant began to admit of symptoms that Lariah was showing in these days after the fall, that she knew she should take her to the doctor, but didn't want to get herself in trouble.
Okay.
And so I think that based on those statements by the defendant and actions, that we have a situation where I'm making the argument this is in fact a child abuse first degree, and that the failure to get the requisite care and well-being for her daughter led to her death.
But you would admit that factually there's distinctions between the two cases as primarily relied upon by the people in this case.
Of course. Yeah, of course.
Yeah, I mean, but yeah, I mean,
I do. They're not the same.
Right, because in one case I have asphyxiation and suffocation where there are these sort of overt acts, right? Even in my son's case, I have people who are not feeding a child.
Right. There's more visible cues and things like that. I 100% agree with the court.
Okay.
Yeah. I'm not, you know me, Judge. I don't try and oversell things.
No, I know. And I'm just, because as I'm looking at it, okay.
And I guess my final point is, I think it's also important to the actions of the defendant, as well as the clear lies that she makes to Detective Sinks, as well as the deputies on scene and subsequent at the hospital. I'm making the argument that does show her consciousness of guilt, even more so that she knew she needed to get help for her daughter. And what's really, really troubling, and it literally keeps me up at night. We have a kid that probably died around 7 a.m. on June the 28th. And the police aren't called until 12:53 p.m. And when the police arrive, we have the defendant theoretically performing life-saving CPR on a child that has been dead for 6 hours and is cold to the touch. And my argument for the court and the people's position is that it's a ploy, it's a ruse. It's trying to distract from the fact that the defendant knew that she was in big trouble because of what had happened to her daughter, and that her daughter was dead and had been dead and was laying in the living room with soiled underwear for hours in a house where nobody bothered to try and get care. And I think that along with these lies that, oh, she died around 11 a.m., she died in my arms, things like that, the court can consider those, obviously, or at least it's the people's position. The court will consider what it's going to consider, but it's the people's position that those sorts of, deliberate, clear lies that are not backed by evidence in any way, shape, or form, along with the defendant's own statements that she knew she should take her child to the doctor, show this consciousness of guilt that she absolutely knowingly and willfully kept her daughter from getting the care that would have saved her life. And that's my argument. Thank you.
All right. Thank you. Mr. Brenton.
I don't want to oversell anything either. I don't know where things stand, but I'll pare down kind of what I was planning on talking about, Your Honor. Following the hearing last time, I did some more digging really into the case law surrounding child abuse in the second degree. And there's a line of cases from the last 5 years or so that define very clearly what an omission is. They look at the word omission in the statute itself. They parse the legislative intent from omission. In the case of People v. Bryant and others, I think make crystal clear that an omission in the child abuse statute does not include medical neglect. And so, the argument that it was an omission that led to serious harm here, it fails because even Maison talks about what omission is, but it's subsequent cases that further define what an omission is and define that it's not including of a category of medical neglect. So I think we can look at all the cases in that light, Your Honor. It seemed like the court picked up on kind of the factual differences between Portelos and Maison in the case at bar. I would also note that a lot of the cases decided about what an omission is come after Portelos and Maison. So we have more clear definitions of what an omission can and cannot be. I did look at the case of People v. Maynard. It's a case in the notes of the jury instruction of first-degree child abuse. It's a leaving the kids in the car case. It elaborates like a two-pronged test for what it means to commit first-degree child abuse. Talking about the statute, it says, thus, this language requires more from the defendant than an intent to commit an act. The prosecution must prove that by leaving her children in the car, the defendant intended to cause serious physical or mental harm to the children, or that she knew that serious mental or physical harm would be caused by leaving them in the car. So there's more of a two-pronged test. It's not just an omission, it's an omission with intent to commit or knew that there would be harm. Frankly, I don't see that there are proofs that Ms. Murray, through medical neglect, either intended harm or knew that there could be harm. There really just weren't any proofs about the child's state between injury and death. It could only be speculation. There were no proofs relevant to that. So we just don't know. The pathologist did testify that he wasn't an expert on what could happen with or without medical intervention for Lariah. He said he could only really speculate as his position for a pathologist. I would just ask the court to look at those cases and take those into account when coming to a decision here. Thank you, Your Honor.
When the court has looked at all of the cases that were referenced by the parties in their, so on the court's recollection of the testimony, one of the things that's in the court's review of the court's notes, I haven't gone back through the video as I didn't foresee it as being necessary. However, you look at there are clear factual distinctions, and one of the problematic things here is the notion that certain actions or inactions alleged by the defendant would require the court, at some point, you're building on these inferences of certain things and trying to piece them together. And I don't know that that's the court's job necessarily at this particular point in time, to try to figure that out. Some of that may have to go to a fact finder if the court finds that it would be proper to the defendant stand trial. It is I could say you're first degree child abuse because you're a horrible mother. And I don't think that that's the court's job either. Or at least a horrible mother as it regards this child and what she should have done or could have done. But one of the problematic things about the cases that are cited is there is some act, there is something. And that was the point that the court was making at the last hearing that we had, giving the people every opportunity to tell me what it is alleged that Miss Murray did. And it just seems like the argument would be one of a negative to get to that point that she did something. Certainly what she should have done in terms of medical care and the like. But realizing that the cause of death being the blunt force trauma to the head, for the most part, or any part, quite frankly, at least according to the medical examiner, there just isn't that connection that the court would see in terms of what Miss Murray did or didn't do. That's a huge distinction for the court in terms of these other cases, because in these other cases, there's something that these people are doing to the child. So in that respect, and after due deliberation and reading through everything, and as the court examines the facts of this case, the court is going to decline to bind the defendant over on the charge of felony murder and or child abuse in the first degree. I also do not believe in this case that the elements, let me make sure I say this clearly. I do not believe that this is indeed a second degree murder case, and don't believe that the defendant should stand trial on the charge of second degree murder, primarily for those same reasons. But, the issue of malice and intent is certainly, or at least malice, implied or expressed, it certainly come to the court's mind as I review the facts as I have them in this case. I think it's appropriate that the defendant is bound over to stand trial and will bind the defendant over on the charge of child abuse in the second degree. I will, as requested by the people, bind the defendant over also for, and I understand their reasons for child abuse in the third degree, and also the charge of involuntary manslaughter. So I will bind the defendant over to stand trial on those three, and I probably should put them in a different order for the purposes of.
I will file an amended information with those three counts in the appropriate highest charge.
Correct. Thank you.
And I'll make sure that that's sent to Mr. Bernstein.
All right. Mr. Bernstein, do you waive presentation of the information at this time?
Yes, Your Honor, I can waive.
All right, and stand mute to those, your client stands mute to those charges and waives its reading, obviously.
Yes, Your Honor.
All right. Defendant having waived presentation, formal reading, court will enter a not guilty plea on the defendant's behalf. Pretrial in this matter will be set
July 10th at 1:30 before Judge Cummings.
July 10th, 2024, 1:30 before Judge Cummings.
Perhaps a Judge Conlon case, I want to say.
I'm sorry, that is, I meant to say Cummings. It is Cummings. Correct date, but it should be Cummings.
What'd you do? You've been doing this all day. So it's
I wasn't calling your eyes, maybe sure I go to the right room.
it's July 10th, 2024, 1:30 before Judge Conlon. Court does call the case of S&C Holdings versus Trevon Steins.
Ready, Your Honor. Tracy Thomas appearing on behalf of the plaintiff.
Yeah, I'm here.
What's your name?
Trayvon Stein.
Okay. What's the claim in the case, Mr. Thomas?
It's a non-payment of rent case, Your Honor. Mr. Stein's total due is $1,754.
Does that include his cost?
It does.
All right. And Mr. Stein, you have a camera?
Yes, sir.
And how do you intend on getting that paid?
I paid $1,000 this week, and then next week. Wait, how much do I owe now?
Well, I don't know. Mr. Thomas, did the 1,000 get credited to?
Your Honor, I got an email yesterday from my client indicating that there had been no payments on this account, so I'll have to look into that.
Yeah, I paid $1,000 this week, and then I can pay the rest probably next week.
By next week when?
I get paid Wednesday, so Wednesday.
So by Thursday, you'll have paid everything.
Yes, sir. I just need a balance. That's about it.
Well, right now they have your balance at $1,754.
Okay.
But what we don't know is if that includes the 1,000 or not.
Okay.
That makes sense to you?
Yes, sir.
All right, so I'm going to put the balance will be paid by May 30th,
Okay.
2024. I'll adjourn the matter to May 31st, 2024 at 12 p.m.
Okay.
All right. S&C Holdings versus Andre Harris.
Good morning, Your Honor. Tracy Thomas here, appearing on behalf of the plaintiff.
Andre, not checked in. Andre Harris, not here. I'll have to adjourn this out. It doesn't look like you paid for the second service, and you did not.
We've got personal service, but Your Honor, I agree with adjourning it. There has been contact between Mr. Harris and my client, and there's an indication that Mr. Harris is seeking some sort of assistance.
All right. Well, they would need to be here to tell me that, but that's all right. I'll adjourn it out May 31st, 2024, 12 noon.
Thank you, Your Honor.
Thank you. Is that it for you, sir?
It is.
All right. You have a great weekend and good holiday.
Thank you. You too, Judge.
Court does call the case of Ann Arbor Sportsplex 2 LLC versus Platt Real Estate Company LLC.
This is Brooke Nosenchuk appearing on behalf of defendant Platt Real Estate Company LLC.
Good morning, Your Honor. Daniel Kramer, appearing on behalf of plaintiff Ann Arbor Sportsplex 2 LLC.
And where are we on this, folks? I have a judgment of possession. Is that?
Yes, and it's been consented to by both the plaintiff and defendant.
All right. I had defendants. I just want to make sure because a lot came in. So defendant's motion for summary disposition. I do not need to do anything with that. If I have a judgment in front of me, I'm presuming.
That's correct, Your Honor. We'll be withdrawing
right.
that motion.
All right. So we just killed some trees for nothing. No, I'm kidding. All right. All right. Okay. Everything looks in order here. And I will sign the judgment. Thank you, folks, for working that out. I'll dispose of this matter.
Thank you, Your Honor.
Thank you, Your Honor.
All right, guys, take care. Have a good holiday. Coachville versus Sunday Brown.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Sunday Brown, you're not here. You have paid for the additional service. Would you? Okay. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Your Honor, Rachel Dornbush, Palace Law, on behalf of the plaintiff. Your Honor, there's rent to retain of $1,499.41. Costs are $173 for a total due of $1,672.41. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue 10 days.
That's it for me, Judge. And
That's it?
this afternoon, you will have a special guest. It will not be me. So
It
have a
won't be
wonderful
you.
weekend.
Well, You have a great holiday, please.
Thanks, Judge. You do the same.
Court calls the case of Amara versus Scoops Cold or Cold Scoops.
Good morning, Your Honor. Jillian Engen for plaintiff.
Ma'am, your name?
Sarah Simmons for Big B Coffee, which is Cold Scoops LLC.
Yeah, could you repeat your name? We didn't catch it.
Sarah Simmons.
You got it? Sarah's. Okay. All right, ma'am. Before we go any further, you're the owner
Correct, of Cold Scoops.
of Cold Scoops. Okay.
Correct.
Is Cold Scoops it's an LLC?
Yes, it is.
Okay. So in order to proceed further in court, Cold Scoops is going to need to have an attorney represent them. The corporation does.
Okay.
Okay. So, how long will it take you to get an attorney on this?
I don't know. It's the first time I'm hearing that one was going to be needed for the LLC.
Say it again. You're a little bit close to your mic, so I'm having some problem hearing you. Okay. Go ahead.
Sorry.
What were you saying?
This is my first time hearing that an attorney was going to be required for the LLC.
Yeah, you're going to have that for the corporation because that's who's here. Yeah. Okay. So this is a non-payment of rent. How much is claimed?
Including court costs, Your Honor, I have a total of $22,833.40.
Okay, you're going to have to repeat that for me. You guys have opposite problems with your mics. So say that again for me, the amount.
I have $22,833.40.
Got it. Okay. What I will do, ma'am, is I'm going to adjourn this out 1 week, allow you an opportunity to get an attorney.
Okay.
To represent Cold Scoops. So I'll adjourn it to May 31st, 2024 at 2 p.m.
Okay.
Okay.
All right,
And then
thank you.
we'll see where we go from there.
All right. Thank you.
Thank you. New Park Ridge Apartments versus Barry Tomlin.
Jillian Engen for plaintiff.
Not having checked in.
New Park Ridge, Tomlin. No, he is not here. If you'd like to proceed, you may be sworn. You raise your right hand.
It's my right hand, Your Honor.
Okay, no, it is.
We still have
Do you
the same
solemnly
problem.
swear? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, please.
Thank you. This is a case for non-payment of rent. I have rent to retain possession of $181.95, court costs of $176 for a total of $357.95. Plaintiff is requesting a default judgment for possession only with the writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days, no writ without a hearing. Calls the case of Z Partners versus J.K. Whitley Investments.
Jillian Engen for plaintiff.
John Whitley with J.K. Whitley Investments.
Okay. And Mr. Whitley, let me ask you this. Is this an LLC or corporation?
It is an LLC.
It's an LLC?
Yes.
Okay. So you're going to need to have an attorney represent the LLC. How long will it take you to get an attorney, you think?
I would imagine 2 weeks at the very most.
All right. How much is owing in rent?
I have a current balance, including court costs, of $20,818.62.
Gotcha. Okay. So, sir, what I'm going to do is I'm going to adjourn it a week for you to get an attorney. All right. And the reason I'm doing it is because of the amount that's owed. And I trying to at least get something accomplished before we click into another month. All right. So I'll adjourn this to May 31st, 2024 at 2 p.m. All right. And then once you have it, then we'll see where we can proceed from there. Okay.
Okay. All right. Thank you, Your Honor.
Thank you. Is that it? Glencoe Hills versus Jermaine Ballard Tab. That matter's dismissed. Oh, Mr. Fields is on back. Oh, there he is. Okay. Beal Properties versus Jennifer Hazelbaker Rollison and Casey Fields. Mr. Fields, you there?
Yes, Casey Field here.
Oh, much better. Much better.
Sorry about the trouble, Your Honor.
No, not a problem. Okay, counsel, what's the claim in this case?
Your Honor, we've got rent owed in the amount of $1,699. Court costs of $214. Total is $1,913.
All right. And sir, how are you intending on getting that resolved?
Well, here on Thursday next week is our next paycheck. Me and Jennifer both work at Multicultural Academy. It's a Title I charter school down on Platte Road. She's actually there at work today. I took off to be here. We should be able to get that amount completely taken care of. I know that new rent will also be coming due on the 1st. I'm not sure if we can support both this back amount and that on the 1st, but 100%.
Well, hold on. So when this back amount, because that's all that I have before me at this point.
Okay.
The 1913. When can you get that paid?
We get paid on Thursday and we'll be able to pay that then.
So you can get it paid by the 30th?
Certainly.
All right. So what I'm going to indicate
schedule it on the 30th when we get it in our accounts.
Say again?
I can have it scheduled on the 30th when we get that money into our accounts. So.
All right. So here's what I'm going to do. I'm going to indicate you're going to pay the balance by May 30th, 2024. I'll adjourn this proceeding out to May 31st, 2024 at 3 p.m. So get that paid, and then this likely goes away, and then at some point you'll have to work on June or figure out June.
Yep, that'll be taken care of as soon as possible.
All right.
I just found out about this last night. I've been dealing with losing my mother and actually canceled my plans to attend her ceremony on the 29th to make sure that this is all handled, because this is important. I don't want to leave anybody short just to take care of other stuff.
Gotcha. Okay. All right. Well, our condolences on your loss.
Thank you.
Okay.
And just to make sure, because I had a number written here of 1833. You said it was 1,913, ma'am?
I apologize. Let me get the file.
Yeah, that was.
Yeah, it's $1,913. It's including court costs.
Okay.
$14.
All right. I will have that submitted to the Beal website as soon as we get paid.
Thank you so much.
All right. Fantastic. Thank you. And Chichester Place versus Wright, Chichester Place versus Franklin. Those matters are dismissed on plaintiff's motion. Oh, hello. Who are you?
My name is Neve Wright.
Say again?
My name is Neve Wright.
Okay, Ms. Wright.
Yes.
They're dismissing your case. You have a problem with that?
No, I do not have a problem, sir.
Okay, I didn't think you would.
Thank you so much.
You're welcome. You have a great holiday.
You have a great holiday as well, sir.
Arbor Woods versus Brittany Woods.
Good morning, Your Honor. LLP 86316 for the plaintiff.
Oh, there's another party. Donovan, come on up. And Sydney, it was a pleasure seeing you.
Good morning, Your Honor. Good to see you.
They told us we were going to have a guest appearance. All right, go ahead. State your name again, please, sir. Donovan Hall. Okay. And what is his current balance at this time? Did he pay you pay the 800?
Yeah, should be paid in full.
Oh, you should be paid in full?
So he paid $810. So he did make the $800 payment. The account is not paid in full. I'm showing that there's rent to retain of $920.41, court costs of $240 for a total of $1,160.41.
Okay, that's what she's showing. What happened?
That's probably, I just paid it yesterday.
What did you pay yesterday?
$11.70 to be exact.
Okay.
So he said he paid $11.70.
So it might not have went into effect just yet.
Got it. Okay, so what I'm inclined to do, unless you were gonna check with the client, is just put it out a week. If he paid it, it'd be dismissed. If he didn't pay it, I'm gonna be mad. Because he told me something that didn't happen. All right, so I'll adjourn this to May 31st,
Okay. Now, would that be Zoom?
2024 at 1 p.m. What, you don't want to come see me?
I don't know.
No, what's up with that? No, if you need to appear, you can appear via Zoom.
Okay.
All right, that'd be better for
You
you.
have a good one.
All right, you have a great holiday.